Welcome to Chapter 5, Constitutional Law. The United States Constitution, the greatest legal document ever written, is a series of compromises about the power of government. The compromises affect every citizen and company in the nation, every day. John Milton once said, "Give me the liberty to know, to utter, and to argue freely according to conscience, above all liberties." Before the Revolutionary War, states wanted a confederation with weak national government and very limited powers. After the war, in 1787, the states voted to amend Articles of Confederation and create a new federal government that shared power with the states. The U.S. Constitution is an amazing document in many ways. It was drafted in 1787, but it's relevant today. It's short and easy to read. It's flexible enough to deal with issues of a changing world. It's versatile enough to resolve a wide variety of conflicts, and it leaves room for interpretation. When America gained its freedom from England in 1783, the states governed themselves under the Articles of Confederation. This gave the federal government no power to raise money or regulate commerce. Taxation policies were inconsistent and caused dissent among states. The Articles of Confederation simply were not working. The states sent 55 delegates to meet and amend the Articles of Confederation. Instead, these men became the framers of the Constitution when they decided that an entirely new document was needed. They debated over how much power to give the federal government, the states, and the people. The result was a series of compromises about power. The Constitution established a federal form of government with checks and balances among three branches: executive, legislative, and judicial. National government has limited powers delegated from the states. The federal government is divided into three branches to help ensure a balance of power. Each branch is independent and equal. While the original Constitution did not mention the rights of citizens, this was added later in the first 10 amendments, or the Bill of Rights. Article 1 established Congress with two houses. Each state has 2 senators, while the number of representatives is relative to the state's population. Article 1 gives Congress certain powers. Congress can create and enact legislation, impose taxes, spend money, create copyrights, and support the military and declare war. Congress also regulates commerce with other nations and between different states. Substantial effect rule states that Congress may regulate any activity which has a substantial economic effect on interstate commerce. Every state has a great deal of power. For example, they can regulate commerce within their own borders, so long as they don't discriminate against interstate commerce, because this is unconstitutional. But with as much power as every state has, there is the Supremacy Clause. This states that the Constitution, federal statutes, and federal treaties are the supreme law of the land. If there's a conflict between statutes, the federal controls the issue and the state statute is void. Even with no direct conflict, federal law will prevail if the issue is one that Congress controls exclusively. So, state law prevails only when there's no opposing federal law and no exclusive federal control. States have clashed with the Supreme Court on many issues. One such case was Barnes v. Glenn Theater. Indiana's public indecency statute prohibits any person from appearing nude in a public area. A nightclub called the Kitty Cat Lounge and several dancers who wished to perform nude filed suit seeking an order that the statute was unconstitutional. The U.S. District Court ruled that the dancing was not expressive conduct. The Court of Appeals reversed, declaring that it was non-obscene expressive conduct and thus protected by the First Amendment. Indiana did not argue that the dancing was obscene. If that were the issue, the Miller test would have determined the outcome. Instead, Indiana claimed that its general police powers, including the power to protect social order, allowed it to enforce such a statute. Does Indiana's public indecency statute violate the First Amendment? The holding was that, although the court was sharply divided, it upheld the statute. The court, per Chief Justice Rehnquist, held that this dance is expressive conduct, but only within the outer perimeters of First Amendment protection. The state has a substantial interest in protecting societal order and morality, and as the statute only incidentally limits some expressive activity, it does not violate the First Amendment. What are a state's police powers? The police powers are the inherent rights of states to enact laws to promote the general health, safety, and welfare of their citizens. Do you think it's important that Indiana did not argue that the dancing was obscene? Possibly. Had the court applied the Miller test to determine obscenity, the result may have been different because the Miller test requires a number of subjective determinations. What specific purpose did the Indiana statute serve? Indiana defended the statute on very general grounds, that it served public health, safety, and morals. It did not specify the particular ills it addressed. Do you think a state law that interferes with expression requires strict scrutiny? Usually. The court's response to this case was fractured, with Chief Justice Rehnquist and Justices O'Connor and Kennedy agreeing that the statute did not violate the First Amendment, and Justices Scalia and Souter concurring in the result, but not the reasoning. Justices White, Marshall, Blackmun, and Stevens dissented. In other words, the only reasoning that commanded more than 3 votes was the dissent. Article 2 defines the powers and responsibilities of the President. In general, he or she is to enforce the nation's laws. The President nominates federal judges and the heads of most administrative agencies. The President and his or her advisors can propose bills to Congress, and then the President can veto bills from Congress. The President coordinates international efforts, negotiates treaties, and is the Commander-in-Chief of the military, but may not declare war. Judicial review refers to the power of federal courts to declare a statute or governmental action unconstitutional and void. This is one of the most important of all constitutional powers, yet it appears nowhere in the Constitution. The Supreme Court simply declared that it had this power in Marbury v. Madison in 1803. It has been controversial ever since. Judicial review is so controversial because the people elect legislators at the state and federal levels largely to pass statutes. In theory, elected representatives pass statutes that represent the will of the majority. Similarly, voters choose political leaders who will recommend legislation they want, sign it into law, and oversee the law's enforcement. With judicial review, one branch of government, the judicial, has taken upon itself the power to nullify laws and actions made by the other 2 branches. Federal judges are appointed, not elected. This means that judges appointed for life have the power to void laws created by the elected representatives. The First Amendment states that Congress shall make no law abridging the freedom of speech. Speech includes nonverbal communications such as signs, symbols, and acts, like flag burning. Political speech about a politician or a political process, this is all protected and can be found illegal only if it's intended and likely to promote lawless conduct. Legal speech may be limited in time, place, and manner. Obscenity is not protected by the Constitution. Commercial speech, designed to propose a commercial transaction, is regulated more strictly than other speech and may be outlawed if it's false or misleading. Sadly, far more Americans can identify Lisa, Marge, Maggie, Homer, and Bart than the First Amendment freedoms. Only 1 in 4 Americans can name more than one of the 5 freedoms guaranteed by the First Amendment: freedom of speech, religion, press, assembly and petition for redress of grievances, but more than half can name at least 2 members of the cartoon family. Texas versus Johnson. In 1984, outside the Republican National Convention in Dallas, Gregory Johnson participated in a protest against policies of the Reagan administration. Participants gave speeches and handed out leaflets. Johnson burned an American flag. He was arrested and convicted under a Texas statute that prohibited desecrating the flag, but the Texas Court of Criminal Appeals reversed on the grounds that the conviction violated the First Amendment. Texas appealed to the United States Supreme Court. So, the issue is, does the First Amendment protect flag burning? Yes, the First Amendment does protect it. The amendment literally protects speech, but the court has long included other conduct that conveys a particularized message. Flag burning is a symbolic speech. As to whether this form of symbolic speech should receive protection, the court stated, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. Nothing in our precedent suggests that a state may foster its own view of the flag by prohibiting expressive conduct relating to it. In dissent, Justice Rehnquist wrote, in holding this Texas statute unconstitutional, the court ignores Justice Holmes' familiar aphorism that a page of history is worth a volume of logic. For more than 200 years, the American flag has occupied a unique position as the symbol of our nation, a uniqueness that justifies a governmental prohibition against flag burning in the way Respondent Johnson did here. The Fifth Amendment states that no one shall be deprived of life, liberty, or property without due process, nor shall private property be taken without just compensation. Procedural due process states that the government must go through procedures to ensure that the result is fair. The process due is in proportion to what the government is trying to take from you. The taking clause says that when the government takes private property for public use, it must pay a fair price. Substantive due process states that some rights, like voting, speech, travel, and privacy, are so fundamental that government cannot take them from you at all. Pursuant to the Equal Protection Clause, the government generally must treat people equally. As with most of the important constitutional protections, government means not only the federal, but also state and local governments. And yet, many statutes do make classifications. States classify citizens based on age for purposes of drinking, obtaining a driver's license, voting, attending school, receiving health benefits, and many other purposes. Most such classifications are legal. To know whether a classification is lawful, the first step is to specify what is being regulated. That will determine the level of scrutiny a court will apply to the regulation, which in turn will make the outcome of the case predictable. When thinking about the Equal Protection Clause, a question arises. Does lower tuition for in-state residents versus non-residents at state universities violate the 14th Amendment? You may know that non-residents pay higher tuition than residents at state schools, but you may not know why this practice does not violate the Equal Protection Clause. There are many other examples you may be able to think of. Where non-residents have to pay a higher fee than residents. For example, fishing and hunting licenses. Non-residents pay higher fees for beach access. Courts apply the rational basis test to ascertain the constitutional validity of higher non-resident tuition because it's a classification based on economic relations. Basically, if you are paying taxes within a state to help fund a state institution like a university, you should perhaps have lower tuition. Courts have consistently upheld higher non-resident tuition. Higher non-resident tuition tends to distribute more evenly the cost of operating and supporting a state university between residents and not residents. Although there is no way for the court to determine the degree to which the higher tuition charge equalizes the educational cost of residents and non-residents, it appears to be a reasonable attempt to achieve some kind of equalization. The regulation classifying students as residents or non-residents for tuition payment purposes is not arbitrary or unreasonable and bears a rational relation to a school's purpose of financing, operating, and maintaining its educational institutions. Courts typically upheld uphold higher fees for non-residents when charged for access to limited state resources, which the state has husbanded through expenditure of state funds collected from taxpayers. If you want to live in a particular neighborhood, you may have to give up some of your constitutional rights. Would you be able to do this? For example, some neighborhoods have strict covenances which may supersede constitutional protection. They may restrict whether or not you can own pets, what color you can paint your house, what the size of your mailbox, whether or not you can decorate your home or place signs there, and even whether or not you can have children. These restrictions are enforceable because the owners voluntarily accept them. The U.S. Constitution, the greatest legal document ever written, is a series of compromises about the power of government. The compromises affect every citizen and company in the nation every day.